Hello, everyone. Welcome to a series podcast where we dive into everything healthcare. I appreciate you for subscribing to my channel, and if this is your first time, please click the subscribe button below to stay updated with our latest episode. I'm your host, Sonny Clement. Today, we're going to be discussing the topic 6 Nigerian laws which protect patients' privacy. In Nigeria, patients' privacy and the handling of medical records are governed by various laws, regulators, and professional guidelines. These legal frameworks aim to protect patients' personal health information and ensure that it is handled with confidentiality and care. In this podcast, I'm going to be sharing with us some of the laws, key laws that we need to be aware of, either as patients or healthcare providers.
This podcast is sponsored and brought to you by HealthShare Integrated Solutions.
Number one is the constitutional provisions, right to privacy. The Nigerian Constitution provides a general right to privacy under Section 37, which includes the privacy of citizens, homes, correspondence, and communications. This right extends to the privacy of medical records. Number two is National Health Act of 2014. The National Health Act of 2014 is the primary legislation governing healthcare in Nigeria. It includes specific provisions on patient confidentiality and the handling of medical records. Section 26 of the National Health Act of 2014, this section requires healthcare providers to maintain confidentiality of all patients' information. Patient records can only be disclosed under specific circumstances, such as with patient's consent for legal reasons or when it is in the public interest. Patient rights is another part. The Act also outlines the rights of patients, including the right to access their own records and right to confidentiality regarding their health status. Number three is Code of Medical Ethics in Nigeria, 2008. The Code of Medical Ethics, published by the Medical and Dental Council of Nigeria, MDCN, provides guidelines for medical practitioners on maintaining patients' confidentiality. It emphasizes the patient's information should not be disclosed without consent, except in specific situations where disclosure is legally required or ethically justified. The code also includes provisions of proper maintenance of the medical records, ensuring they are accurate, they're secure, and only accessible to authorized personnel. Number four is Cybercrimes Prohibition Prevention Act of 2015. Although primarily focused on cybercrimes, this act includes provisions on data protection, especially regarding electronic health records. It criminalizes unauthorized access to electronic data, including patients' records. Number five is the Nigerian Data Protection Regulation, NDPR of 2019. The NDPR, issued by the National Information Technology Development Agency, NIDA, establishes comprehensive data protection guidelines. It applies to the processing of personal data, including health information, by any entity operating in Nigeria. The NDPR requires that data subjects, including patients, provide informed consent before personal data can be processed. This is very serious. It also mandates that data controllers ensure the security of data and handle it in a manner that respects the privacy of individuals. Number six is Freedom of Information Act of 2011. While the Freedom of Information Act promotes transparency, it also recognizes the need to protect personal privacy. Section 14 of the Act exempts personal information, including health records, from disclosure without the consent of the individual concerned, unless the disclosure is in the public interest. Number seven is Professional Practice Guidelines by the Nursing and Dental Council of Nigeria, which also stress the importance of maintaining patient confidentiality and proper record keeping practices. Healthcare providers who breach patient confidentiality may face legal consequences, including civil lawsuits for damages, disciplinary actions from professional and regulatory bodies, penalties under relevant law. In summary, Nigerian law places a strong emphasis on protection of patients' privacy and the confidentiality of medical records. Healthcare providers must comply with these laws to safeguard patients' information with specific guidelines and legal provisions, ensuring that patient data is handled with high standards of security and confidentiality. This is very important for them in order for them not to avoid any form of litigation. That's a wrap for today. Thank you for joining us on Health Series. We hope you found today's episode both insightful and valuable. If you have enjoyed the discussion, please remember to subscribe, rate, and leave us a review. It helps us to reach more listeners like you. Don't forget to follow us on Facebook, Instagram, TikTok for updates on Head Series and to connect with our growing Head Series community. If you have any questions, suggestions for topics or guests you would like to hear from, feel free to reach out to us via the email displayed on the screen. We'd love to hear from you.
This podcast is sponsored and brought to you by HealthShare Integrated Solutions.